25W716781. Your name?
John Graziani, P number 43387.
He didn't show up?
Judge, he did show up. In fact, he's been waiting. And in defense of him, he's been out there. Officer John had witnessed me making a phone call to him. He didn't answer the phone. He apparently had another issue in the 28th District Court, although they didn't appear till 1 o'clock. But like I said,
Say
Judge,
that again?
he had a separate issue and he had to be in Southgate, the 28th District Court.
At what time?
I believe we had until 1 o'clock to show up.
Well, it's only 22.
No, understood, Judge, and I'm asking,
I'm issuing a warrant for him. I'm not gonna play with these guys.
but Judge, also in addition to that, there's been a bit of a breakdown in our relationship.
That's too bad. He doesn't have the right to not show up.
No, Judge, in his
This case is 2 months old.
No, Judge, again, in his defense, he has been out there for over 2 hours. I just let you know. Understood, Judge.
Well, so you never got a chance to talk to him?
I did talk with him, Judge. There's a bit of a difference in opinion at this time. He has mentioned Jeff Bowditch and other MIDC attorney, and a very decent gentleman, and I have no problem, Mr. Bowditch, taking over this matter.
He can't. They don't get.
Well, then,
What's your name,
Mr.
sir?
Hensley's right over.
Come on up here.
There is right there.
Again, Judge.
Your name?
Johnny Counsel.
Where were you?
I had to go to the parking lot for a second. I've been here since.
Mr.
Judge, he's been there since approximately 9 o'clock. He
Okay, so
has been here.
So, listen, look at,
Just look at it.
we're not going to chase you around, Mr. Hensley.
No, I've
Stop. This case is 60 days old. I'm not going to play with it much more.
Now we shift gears from scheduling chaos to serious public safety concerns. This tether testimony matters because house arrest isn't just a suggestion, it's a strict bond condition. What's interesting here is the distinction the court makes between a technical malfunction and intentional tampering. A strap disconnect doesn't automatically mean guilt, which is why the judge gives the defendant the benefit of the doubt, for now. But notice the pressure building: missed calls, failure to report, and the fact that the victim is notified every time this tether disconnects. That adds emotional weight and risk. So here's the real question: should repeated technology issues still count as violations when the defendant doesn't follow up?
I believe it needs attention that someone can.
July the 17th is when you were arraigned. That was 14, that was 45, that was 54 days ago. I'm not playing with it anymore. You told Judge Hessen, it looks like, you were going to retain counsel on July 29th. Right?
Yes, sir. But
Slow down. You came back in front of her on August the 12th. I don't know what happened August the 12th, and I don't know why you didn't retain your lawyer by the time.
I was afraid that
He was.
I was at the county.
For what?
Related case with my neighbors. They've been pecking at me for
All right, stop.
years.
All I can tell you is I'm gonna move the case. Okay,
I feel that it needs attention.
I'm sorry?
I feel
You
it
don't-
needs to be.
You don't get to pick your own lawyer. Okay, you wanna pick your own lawyer, you go hire your own lawyer. Nobody on these MIDC rules has ever conveyed to any judge in this state, defendants get to pick their own lawyer. You wanna pick your own lawyer? Save your money, go hire your own lawyer. You can hire today's modern day version of F. Lee Bailey if you want, but I'm not adjourning these cases ad infinitum. Not gonna happen.
I'll get a lawyer if that's what you want.
He doesn't want.
You told Judge Hessen you were getting a lawyer July 29th. That was 42 days ago.
I agree. I did.
Now, if you want a lawyer, hire a lawyer.
I called Jeff.
I don't care.
Bogachev, and he said that he was busy. Stoppage. And he said that he was busy working the, Inkster.
Well, so in other words, he couldn't hire you. You couldn't hire him.
No, he couldn't come. He
Right.
said, "Fine."
Right.
But, you know, when I talked to him, he's running around with all these people and he's not giving my case a look at. He hasn't even seen the film or the, you know, I guess the footage of what happened that day or nothing, sir.
This is his first appearance on your case
I
today,
know, I agree.
right, Mr.?
And he needs to.
Yeah, it is-
Stop.
It is my first appearance in Judge. I have no problem with someone else taking over.
I know,
We
but
got no
I
point for
actually
broken
would
down.
like him to do it as long as he could take and do the discovery.
wait a second.
Because I don't want to bug Jeff.
Wait a second. You don't get to keep interrupting either.
Okay.
That's at least the third or fourth time.
So,
Okay,
go ahead again, sir.
good. Listen. If you think there's been a breakdown, you can move to withdraw. Otherwise, I'm adjourning this a week.
Judge, I am withdrawing. I moved to it. I thought it was mentioned on the statement.
Well, you
by
did.
Attorney Mohammed. I would like to withdraw on this because based upon the breakdown that we've experienced, I don't believe that I'd be totally capable of doing a 100% good job on this, Judge. And I get it, Judge, you've got to move your docket, but with this gentleman's demeanor, he's a good person, he's a hardworking gentleman, but he just doesn't seem to get it when I explain some of the things.
Do you have any objection to him withdrawing?
No, sir. No, sir, because
I don't need
I
to.
talked to him and
I don't need to hurt here. I'll find there's a breakdown in the attorney relationship or attorney-client relationship. At least I'm adjourning this 1 week to the 16th. I don't know who we're gonna get to represent you. You're still free to go out and hire your own. You don't have to. I'm adjourning this to September 16th at 8:30 in the morning, and I want you to understand, I'm gonna set it one more time. If it doesn't resolve it, I'm gonna set it for a final pretrial and a jury trial if it doesn't resolve on the 16th. So I'll let you withdraw. At least I don't know who we're gonna get on this list, but find somebody, please, and then he'll be back here in a week. And I'll appoint that lawyer. You can let him know that it's been going on, and I'd like them to review the discovery and determine whether or not it can be resolved. If not, I'll set a final pretrial and the jury trial date.
Judge, thank you so much.
Okay?
thank you, Your Honor.
All right.
Thank you.
Good luck. Now come in person. I want you to come in person next week. You understand?
Oh, for sure. I'll be.
Okay. Good enough.
Tomorrow's my birthday.
Well, happy birthday.
Sir.
Your name,
Detail dumps.
Mr. Turner, your name.
Matthew Turner.
Detective Tulas, your name.
Okay.
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Sorry?
So I'm going to first find out from you, Mr. Turner, what you can tell me. Do you have personal knowledge of the facts and circumstances of this case, to wit, with respect to the tether that was placed on Mr. Demps?
Yes.
I'm going to ask you to raise your right hand, please. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you God?
Yes, Your Honor.
All right. Your name?
Good morning, Your Honor.
So we've been waiting for Mr. Demps for quite some time. I was told, and I'm going to read you the email or memo. Defendant needs to report to house arrest as soon as possible. They've had it at least 2 occasions where there's been an extended strap disconnect with his tether. House arrest has attempted to reach out to him via phone, but they've not been able to reach him. The victim was notified each time the disconnect happens. Needs to, in house arrest, needs to see him so they can check his equipment. They'll determine if it's an equipment issue or if it was tampered with. They attempted to contact him via phone. And then they list the phone number. Are you able to confirm that this is still his number? I did confirm that. I was told by, come on up, Ms. Wiles, that that house arrest had contacted him Sunday. The defendant acknowledged that. He said that he I believe, did or did not, I don't remember if he said he contacted them. Ms. Wild's your name?
Elizabeth Wasserman, Your Honor.
I don't think he contacted them. Did he contact you guys, Mr. Turner?
The only time he contacted us was Sunday after the initial missed call. We called him about the strap tamper. He did not answer at that time. He did call back and was advised to come in on Monday, September 8th, to get that looked at. He acknowledged that he would be here and he did not come yesterday.
But do you have any questions of him, counsel? Of this, Mr. Turner? Yeah,
Mr. Turner,
house arrest. He's the tether company.
the one question I have is, was he around the complainant's address?
Can you tell us where that tether indicated that the defendant was? It was actually disconnected, right? I think I can answer that. So you don't know, correct?
I apologize. With the strap connection, there's two things that have to fail. One is the extended strap disconnect means that there is something that needs to be looked at. It could then turn into this tamper becoming the tether off the leg, which is why we would need to see them as soon as possible for an equipment check. At the time of the tamper, he was at 21871 Stratford Place Boulevard. Looks like an
Stratford
apartment
Place
home.
Let me see here. Stratford Place.
Your Honor, I believe that is his residence or nearby.
That is whose residence?
Mr. Demp's.
I have Mr. Demp's residence as Kings Point Boulevard in Brownstown.
Right, which is within
Residential.
Stratford Place.
That's within Stratford Place, correct?
Yes, Your Honor.
Do you have any questions of Mr. Turner?
Mr. Turner, what time did you talk to my client on Sunday?
I did not speak to your client. One of my coworkers did speak to him at, see, it was, oh, that was Sunday. 1:19 p.m.
Okay, he was told to come in on specifically, physically come to house arrest on Monday
Correct.
but not by you, by your coworker.
Correct.
How do you know that?
I have the voice recording from the phone call.
Okay, where you specifically told him to come in physically on Monday.
Correct.
Did she give a specific time?
No, that he had to be here before 7 p.m. and that he should come in the morning first thing.
And did Mr. Demp's acknowledge that?
He did.
And then was there any further communication?
All right, buckle up because this courtroom session spirals fast. We're dealing with missed appearances, a frustrated judge, a defendant who says he showed up but can't seem to stay put, and a legal system that's officially out of patience. From attorney breakdowns to house arrest violations, this case is a perfect storm of miscommunication, courtroom tension, and consequences that could change everything, so stay locked in, because this judge is not here to play games.
We attempted to reach out to him yesterday at 12:12 p.m. It went to voicemail.
Okay, now, and the situation with this faulty strap, is this a common occurrence?
It is not, but technology does have issues at times.
Okay, now is it possible that with the faulty strap, the tethers, I guess, the functionality could go in and out?
Yes.
Okay, but without necessarily involving any tampering on whoever's wearing it, on their part?
Correct, which is why we would need to see him for an equipment check to ensure that he did not tamper with the device.
Okay, now what are the reasons that this could potentially happen with the tether?
The band is made with a fiber optic cable. It could be that, something was blocking that fiber optic connection, something got bumped to where it did disrupt that fiber optic connection, or it could have been that he was trying to remove it.
Okay, or could it possibly be also, sir, just ordinary wear and tear on a tether that's been in service for a while?
On the strap, yes.
Thank you.
I'm calling the halt to this. You're to go to house arrest by 2 p.m. today. If you don't do that, I'm going to consider this to be a bond violation. I'm going to give you the benefit of the doubt for the time being. It doesn't sound like anybody can prove that you intentionally caused this disconnect, but as of now, you're going out there today by 2. You don't go today by 2, I'm telling you, I'm going to forfeit your bond, revoke the release, and set a really high cash bond. Do we understand one another?
Yes.
You go to house arrest by 2 p.m. today. I'm scheduling this. It will remain for September 16th. This is the exam at 10:30. However, it might be that if they know, you notify Ms. Wilds of your findings, if it turns out that there was an intentional disconnect, whatever day Mr. Carmen is here this week, we will have a hearing, okay? To determine whether or not that was intention.
Thank you, Your Honor.
All right, you understand, sir?
Yes.
Go down the hall, get your notice, and you come back, you go at the house arrest by 2, so you better get going. Good luck. Thank you.
Thank you, Your Honor.
Thanks.
So let's wrap this up clearly. In today's courtroom, we saw two major legal themes collide: accountability and patience, both wearing thin. The judge allowed counsel to withdraw due to a breakdown in the attorney-client relationship, but made it clear the case is moving forward, with trial firmly on the table. In the tether matter, the court extended grace ordering immediate compliance, while warning that any failure could result in bond revocation and jail time. This wasn't leniency, it was a final warning. If you found this case as intense as we did, hit that like button, share this breakdown with someone who follows courtroom drama, and subscribe for more real, unfiltered legal moments just like this. Drop your thoughts below. Was the judge fair or too patient?